There are wins in this line of work that feel good, and then there are wins that change you. This was one of those. Hi, I'm Joel Chorny. I'm a criminal defense attorney in Tucson, Arizona, and today I want to tell you a story of a trial that I almost talked my client out of. A case that I didn't really think we could win. A case that ended with a directed verdict, something so rare, most lawyers go their entire careers without seeing one granted. Now, let me break that down for anyone watching who didn't go to law school. A directed verdict is the legal equivalent of the judge saying, "You haven't made your case, and I'm not going to waste the jury's time." The prosecution presents all their evidence, and the defense says, even if we believe everything they just said, it still doesn't add up to guilt beyond a reasonable doubt. And if the judge agrees, that's it. Case dismissed. No deliberation, no need for a defense case, and it almost never happens. And it only happened in this case because I listened reluctantly to my client. Several years ago, police responded to a call at an apartment complex. A group of 3 people claimed that my client had been harassing them, verbally and physically, and that he had tried to follow them into a vending machine room. When the police arrived, they found my client visibly intoxicated in the parking lot. They ordered him to the ground at gunpoint. Body cam footage shows that my client was complying, he was confused, and he was very drunk. He had red eyes, slurred speech, and when asked what he had to drink, he said 6 beers and a blunt. Later, an officer pressed a car key fob in my client's pocket. It matched a white Camaro in the lot. A car with 2 flat tires, a half-full beer can in the center console that was cold to the touch, and my client's name on the registration. One witness told police that they had seen my client drive into the lot in that Camaro. On paper, this was a straightforward aggravated DUI case. My client's license had been suspended from a prior case, and the state thought they had him. I told my client, "Don't take this case to trial. We're going to lose." He looked at me and he said, "I'm not going to lose because I was not driving." We fought, we argued. I didn't believe him. I even asked to be taken off of the case, but he wouldn't budge. And when a client insists on trial, that's what you do. So we prepared. More than 2 years after the incident, I finally got to interview the key witness, the one who said that they saw my client driving. But something surprising happened. The prosecutor had sent that witness the police report in advance. Not the witness's own statement, mind you, but the officer's version of what the witness supposedly said. That already had me on edge. But then the witness said something I'll never forget. They described the car not as a white Camaro, but as a black sports car with a white logo. I thought maybe he misspoke, so I asked him to repeat it, and he said it again and again. That was the moment I realized we have something to argue about. The entire foundation of the state's case was that my client had driven that specific car, and that had just cracked wide open. From the start, I made a conscious choice. We were going to concede impairment. Why? You see, credibility is the currency of trial. And if you want a jury to believe you when it matters, you don't pick every fight. My client was undeniably drunk. Fighting that would have made me look foolish. I wanted the jury focused on the one thing that did matter. Did the state prove that he drove? We leaned into that theme hard. My law student who second chaired the case and I built a strategy around the idea of broken telephone. Messages that get passed along, distorted, misinterpreted. We conceded the obvious, and we challenged the assumption. During trial, I started to pick up on something. The judge made a comment about waiting to hear how the state would tie the moving car to my client. Her tone, her word choice, it felt like she was quietly telling the prosecutor, "You need to close this loop, or I won't." And I realized something. If the state rests without making that connection, the judge might actually be willing to grant a directed verdict. So I shifted gears. I waived cross-examination on the crime lab tech. I stipulated to his credentials. I did everything I could to speed things up, to help the state finish its case. And when they rested, I moved for a directed verdict, and the judge granted it. I have had a few directed verdicts in my career, but this was the first one that I saw coming, and I helped bring it about. Afterwards, the jurors told me that they were thrilled. They had already decided to acquit my client. They couldn't wait to see what I would do next. The judge even told me that it was the first time she had ever granted a directed verdict, and that she was grateful that I had moved things along because, frankly, it needed to end. But the person who deserves the most credit, my client. He never stopped saying, "I didn't drive. I'm not going to lose a trial." And I didn't believe him. I tell this story to remind myself, and maybe to remind you, that listening to your client isn't just good ethics, sometimes it's good strategy. If you're a law student, a young lawyer, or even just someone who wonders how these cases get won, I hope this gave you a glimpse of what it's really like. I'm Joel Chorny. Your rights matter. Protect them. Stay safe, and I'll see you in the next video.